The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. The next case is Wells Fargo Bank versus Stocks et al., and we will hear from the appellant.
Good morning. Chief Justice Newby, Associate Justices of the Supreme Court. May it please the court, my name is John Benjamin and I represent Wells Fargo Bank NA in this appeal. I'd like to take 20 minutes of the 30 for my opening argument and reserve 5 for rebuttal. I understand the other appellant will take 5 minutes. That's the State of Francis Stocks after I conclude my 20 minutes. The issue in front of this court today is a critical one. This issue is fundamentally whether or not the statute of limitations for claims that involve conveyances of real property or reformation on claims of mistake run from date of discovery of that mistake or fraud, or run from the date of execution of the conveyances of those real property or those documents signed under seal. The majority in the Court of Appeals held that it runs from date of execution and not date of discovery. We contend, and we'll get into that a little bit later, but we contend that that ignores over 115 years of precedent from the Supreme Court on that point. Fundamentally, the decision's flawed because there'd be no need to have reformation if a party was charged with knowing they'd been defrauded at the time they were defrauded, and or knowing that they made a mistake, they wouldn't make the mistake. So there'd be no reason to have reformation. The decision has drastic consequences for financial institutions and for any party to a deed in North Carolina. A deed has no term. So if you are defrauded in a deed or there's a mistake in a deed, if you have that deed, if it was given to you, you might not notice it for 15, 20 years. Once you get past year 10 under the stocks analysis, then you are out of luck and you can bring no claim to reform that instrument. Same for a deed of trust. A deed of trust typically secures an obligation for 30 years. If you get outside year 10 and there's a default and you go to foreclosure and you discover a problem, even if it's a mutual problem, a problem that the document doesn't evidence the party's agreement, you can't fix it. That's exactly what happened here. Dr. Stocks obtained a loan for his daughter, Tia Stocks, because she couldn't qualify for one on her own, and she used that money to buy a house. This happened in 2002. And Ms. Stocks signed all the loan documents, not just the deed of trust in her own name, but also the note and deed of trust in her father's name under a power of attorney. She made all the payments for 3 years and lived in the house. In 2005, the loan was refinanced. So she had a better interest rate, lower monthly payments. In that situation, in that refinance, the father signed the note, Dr. Stocks signed the note, and Ms. Stocks signed the deed of trust. And Dr. Stocks' signature appeared nowhere on that instrument. And that fundamentally turned out to be the problem that we discovered in 2017. Mr. Stocks died in 2014, and Ms. Stocks made all the payments through not May 2014 when he passed, but actually through December 2014 after he died. In January 2015, she didn't make that payment and hasn't made any since then. Foreclosure was started. My office in 2017 discovered that there was an enderly problem with this deed of trust, meaning that the deed of trust defined the note as being signed by the borrower, and the only borrower under that instrument was Ms. Stocks, and she did not sign the note. It should have either had his signature on that deed of trust or defined the note such that it referenced the note signed by Dr. Stocks. Wells Fargo filed the reformation action and brought this matter on for summary judgment in front of Judge Height about almost exactly 3 years ago. I think it was April 25th. And in that argument, we argued that 152.9 was the correct statute for the statute of limitations, and that this claim was discovered within 3 years of when the default happened and within months of it actually being discovered. In response to that argument, and we'll get into this a little bit later, Ms. Stocks didn't present any evidence at all on when it should have been discovered or any intervening event. All she said was that the documents were signed 12 years ago. You should have discovered it then. I'll note right now that the argument's changed a little bit on appeal. On appeal, what they're saying is they said it should be discovered 12 years ago or sometime in the intervening period. That argument's nowhere in the record. The other argument that Ms. Stocks presented to the trial court, and really the focus of their entire defense, wasn't that reformation wasn't proper and wasn't that the thing was barred by the statute of limitations. There's not really a paucity of information in the record where they actually argue any of that. It was that she was a surety under the deed of trust and had no liability on the obligation unless and until the bank collected on that note. That's not the law in North Carolina. That argument's been abandoned on appeal. The Court of Appeals, this went to the Court of Appeals, and Ms. Stocks said there were issues of fact for both the reformation and the statute of limitations argument, and we disagree with both those, and I'll get to that at the end of my argument. But the Court of Appeals then, she argued 152.9 applied to the analysis of when the statute starts, and 152.9, as the court is aware, has a specific discovery provision contained within it. So if they apply 152.9, they had to make a finding that Wells Fargo discovered or should have discovered it prior to 3 years before the lawsuit being filed, and no such finding was done. They found that 147.2 applied to the exclusion of 152.9. And in doing that, they said that it was the more specific statute dealing with claims for reformation or mistake. We disagree with that analysis for multiple reasons, mainly because the more specific statute is the one that references fraud or mistake, and that's the one that this Supreme Court has applied for over 115 years to reformation actions, including those of deeds and deeds of trust. The court extended the Nation Star decision. An opinion came down in 2018 after I argued my matter in front of Judge Height. A Nation Star opinion came down in which the Court of Appeals found that the applicable statute of limitations was 147.2, and they found that that was the more particular of the two statutes, and that's the one that should be applied here. There's no discussion in Nation Star as to accrual, and what Stocks did was extend that. They actually, in their opinion, say there was a discussion, but there isn't. They extended it and said that it starts at execution. So to reach this conclusion, the majority had to do two things. Had to find that 152.9 did not apply because that has that explicit language that runs from data discovery. And two, it had to find that if 147.2 does apply, that data discovery doesn't matter because those words aren't contained within the four corners of that instrument. I said earlier that this court has for over 115 years applied 152.9 to reformation actions. We've cited a bunch of cases in our brief, but the bottom line is the Supreme Court has held it doesn't matter how long the interval is between the fraud or the mistake. What matters is how long is the interval between when you discovered it or reasonably should have discovered it.
Mr. Benjamin, let me ask you a question. I'm looking at the trial court's order granting summary judgment in April of 2018, I believe it is.
Yes, Your Honor.
And as I read it, and tell me if I'm missing something in here, the trial court reformed the deed of trust to redefine borrower to include Dr. Stocks, but I don't see where he addresses what statute of limitations is being applied. Is that in here somewhere that I'm just not seeing it?
No, Your Honor, it wasn't in there, and typically in summary judgment motion orders, I don't have that in the order, which statutes argued. It's in the transcript. In the transcript, it's also in the brief that we submitted to the record. I can give you those record sites if you like, but all that's what the basis of the order was, but it's not in the order itself.
Well, he also in the order states that he's reforming it, but it's not clear to me from the order itself what the basis is. I don't see him addressing mistake or fraud specifically. Is that in there somewhere or in the transcript someplace else?
No, Your Honor, because if he granted our motion, and it's in our motion, the basis of the claim was that it was based on mutual mistake. The reformation action was based on mutual mistake, that all parties intended for it to collateral this property to continue to collateralize the loan, just like it had in the original transaction. So if the summary judgment order is granted, of course, as you know, there are no findings of fact or conclusions of law, because then there wouldn't be appropriate to have a summary judgment order. The order just granted our motion and then ordered the relief that we asked for in our motion.
Well, the order is longer than we typically see, which is sometimes just a paragraph. This one's several pages. And so it does have some more detail, but it appears to be mostly in conclusions of law. I guess the other question that I have is what would be the effect of the warranty, the deed of trust, I mean, that was signed only by Tia Stocks? What rights would that have given to your client?
Well, first, if I could address the first statement, the reason the order is longer than what you'd see in a normal summary judgment order, you're correct that we normally just say summary judgment's granted and the relief's there. The decretal section, it's not the conclusions of law, it's the decretal section that gives you all the length there, and that's because we had to tell the court had to specify what he wanted done with the instrument, where to record it, and then how to carry out his order. So that's required, I believe, in a reformation action, and that's the way I've done all of the hundreds or so that I've done. I think the judge's order's proper on that point. What is the effect of the deed of trust, reformed or unreformed?
Without having been reformed, what would be its effect or its potential value to your client?
Zero. Nothing, because it doesn't properly describe the note. There's a case called Enderley, which says that the deed of trust must, it's a court of appeals case, and I can give you the site if you like, I have it in my materials here, but it says that the deed of trust has to describe the note with sufficient detail so that it's clear the loans collateral, the deed of trust collateralizes the loan. And so the reason reformation is there, because all parties intended for that to happen, was to fix that problem.
Well, while certainly, you know, from a legal standpoint, from an equitable standpoint, the fact that an individual is making payments and has executed a deed of trust, you're not saying that there wouldn't be an equitable argument with regard to liability on the note just based on these circumstances. You're not conceding that, are you?
I'm not conceding it, but I've never presented that argument to the trial court or appellate court in my career. So I'd have to research that issue. I can tell you that the deed of trust, when you sign the deed of trust, paragraph 9 of that instrument, in this case, paragraph 9 of our deed of trust, this describes what the obligations of a borrower are that just signs the deed of trust. And it makes it clear that they're not liable on the note. It says, I think it's, give the record site. It's page 466 of the record. And it says that it's called successors and assigns, joint and several liability. Co-signers, borrower's covenant, and agree that borrower's obligations and liability shall be joint and several. However, any borrower who co-signs the deed of trust but does not execute the note, a co-signer, is A, co-signing this deed of trust only to mortgage, grant, and convey the co-signer's interest in the property under the terms of the deed of trust, and B, is not personally obligated to pay the sums secured by this deed of trust, and agrees that the lender or any other borrower can agree to modify the terms, and so on. So typically what happens is, you know, if you can't qualify for the loan, the spouse, only one spouse will get the loan, and then both sign the deed of trust to release any interest they have in the real property in case the loan doesn't perform. So back to, unless if I've answered your question.
I had one other question
Sure.
about the deed of trust after it was executed by Tia Stocks, has on the first page of it, when recorded, returned to Wachovia Bank. Is it your position that Wachovia shouldn't have known that there was a mistake, even though the original was returned to it?
It is our position that that a mistake standing alone in the instrument isn't enough, and there's cases on that. A lot of cases, there are numerous cases that say the mere registration of the deed is not enough to serve as constructive notice. If you look at, goes back again to 1907, the Modlin versus Roanoke lumber case, the Supreme Court said registration of the deed is not sufficient for constructive notice. It runs 3 years from the date of discovery. Actually, there's a 1906 case, Peacock v. Barnes case, that says the registration of the deed is not sufficient to start the clock, but it's the date that it should reasonably have been discovered. And then Dale versus Dale, the Supreme Court case, again saying the registration of the deed showing the mistake on the face of the instrument is not enough to serve as constructive notice. There is the Coleman case, the Court of Appeals case that has been discussed a bunch in the briefs, and the Pelletier case, Pelletier versus Interstate Cooperative. So I believe as a matter of law, that's not enough. And in fact, that's why this court was, that's why the court, sort of, the big issue in my view is that 152.9 has to apply to reformation actions for instruments under seal. What we have now is a dangerous precedent with Nation Star and the extension of Nation Star, where discovery's been removed and really reformation has been grossly weakened for any conveyance of real property, anybody that's been defrauded in a real property transaction or something under seal. That's the biggest issue on appeal in my view. And there are two reasons why that should happen. One is, in our view, the court should reverse the court, this court should reverse the Court of Appeals. First, the Supreme Court has spoken for over a century, as I talked about, on that issue. And number two, and I won't go through all these cases because I want to make sure I save enough time for the rebuttal, but most of the same cases I just cited to you, the Peacock versus Barnes case, the Moblin versus Roanoke Lumber, there's Lee versus Rhodes. And by the way, Lee versus Rhodes, Your Honors, and Muse versus Hathaway are two cases where there were two statutes at play, a 10-year statute and a 3-year statute. It wasn't the statute under seal, but it was another 10-year statute. And the Supreme Court specifically said that it's the 3-year statute for fraud and mistake that should apply. But the court has uniformly done this. I've looked at every reformation action case that I could find in all of North Carolina and haven't found one instance where 152.9 was not applied to an instrument under seal or to a deed until I get to Nation Star, which was 2018. It didn't come to the Supreme Court, so you didn't have a chance to fix it. And then also stocks. The other reason that I think 152.9 is the right statute to apply is it's the most specific one, as I referenced earlier. It specifically deals with claims for fraud and mistake, and it runs from data discovery. And also, this is important because I bet this doesn't happen too often at the Supreme Court level, but all the parties agree that that's the statute to apply. We've said 152.9 should apply. The other appellant says 152.9 should apply. And Ms. Stocks, in page 22 of her brief to this court, says the statute of limitations, on page 22, the statute of limitations for seeking relief based on mistake is 3 years under 152.9. The cause of action does not accrue, however, until discovery by the aggrieved party. If the court accepts this position and continues to apply 152.9 as it has for over a century, then the discovery rule will be applied to reformation actions because it's in the rule itself. It's in the definition. It runs from discovery. If the court, however, decides to apply 147.2 to instruments under seal, either in addition to or instead of 152.9, we believe that still should run from discovery and or the date it should have been discovered. And that was our argument to the Court of Appeals. We had to deal with the Nation Star opinion that was binding authority on them, and we said it ran from data discovery very clearly in 3 pages of that brief, pages 28 through 30 of our brief to the Court of Appeals.
The majority opinion says in the slip opinion on page 8 that neither party disputes that Nation Star mortgage and section 1-42 subsection 2 govern this appeal. Is that a misstatement?
No, well, yes and no. We always took the position that 152.9 was the correct statute at the trial level. When it came up, Nation Star was decided after we made our argument, Justice Morgan. And so in the Court of Appeals, in a published opinion, said 147.2 is the correct statute. Ms. Stocks never argued that. This opinion was out when she wrote her appellant's brief. She was the appellant, and she never raised that issue in her appellant's brief at all. We did acknowledge, after saying it runs from data discovery, we did acknowledge Nation Star as we had to because it was a binding opinion on that court, and said the court has recently clarified that it's 10 years from, in our view, from data discovery. And what the Stocks court did that's different is they said, no, it's 10 years from execution. And that's not what Nation Star did. Nation Star just said that the claim, Nation Star versus Dean, was a case where they left off at Exhibit A to the deed of trust, and they found out about it within 10 years of execution. The Court of Appeals, in their analysis, said that 10 years, it's 10 years, this was brought within 10 years of closing, the 10 years statute applies, and so it's timely. In our view, what they were doing was saying if they discovered it in year 2 or 3, obviously that's within 10 years. There's no way for facts to come out that wouldn't do it. But they didn't talk about accrual at all, Justice Morgan.
So it's your position that Nation Star should be recognized as being applicable, but that there is still no genuine issue as to material fact in favor of your client?
No, my position is that the reasoning in Nation Star is the same as the reasoning in. So there are 2 parts of this, right? The first part is that Nation Star held without any sort of, in our view, substantive analysis and applying any of the applicable cases, the cases that talk about reformation on fraud or mistake, and without looking at any of the 115 years of Supreme Court authority on the point, and said 147.2, which is the generic statute that deals with instruments under seal or conveyances of real property, was more specific with fraud and mistake claims than 152.9. We think that was a mistake, and that needs to be changed. Okay, that's all Nation Star did. We think that what Stocks did is they then said, okay, it's 10 years and it runs from date of execution, no matter when you discover the fraud or the mistake. In our view, that's doubly problematic, because then you have parties out there that have been aggrieved, that have been prejudiced by this very fraud or mistake, and they can't do anything about it if they find out about it after year 10. So we're asking that this court find that 152.9 applies to all actions for reformation, reverse the Court of Appeals, and make it clear that any action that's brought moving forward is going to be 3 years from the date that you discover the fraud or the mistake, and that will protect people.
So if we were to do that, are you also calling upon us to overrule Nation Star?
I am. I don't think that's the proper. I don't think that was the proper analysis. But I'm about to get to that 147.2. Did I answer you have another question, Justice Urban?
Yes.
Okay. So 147.2, we believe needs, if you're going to apply it, we think the opinion you wrote, Justice Urban, in Chisholm a month ago is directly relevant, because the statute you were reviewing also didn't have a discovery provision in it like 159 does. And I mean, it was very similar to 147.2. So, as you know, this court specifically rejected the notion that a statute of limitations could be triggered by a secret breach, and that it's going to run from the date of discovery, and that from you called some of your previous opinions opaque on the point, and you clarified that the entire principle upon which defendant hinges his argument, which is the statute of limitations begins to run against a plaintiff who has no way of knowing the underlying breach has occurred, runs afoul of our recent decisions and basic notions of fairness. And then you found that it's, as I mentioned, 3 years for breach of contract. So 147.
Counsel, you're well within your co-counsel's time.
Have I spent more than 20 minutes?
You have 7 minutes and 17 seconds left in total.
Okay. I'm sorry. I would just finish with, we believe the record was clear on reformation and on statute of limitation. You can decide those as a matter of law, and we believe that the trial court correctly granted summary judgment in our court's favor. And I reserve the rest of the time for rebuttal. Thank you, Justice.
It's my understanding that the counsel for the estate will argue next.
Yes, good morning, and may it please the court. Chief Justice Newby and Associate Justices, my name is Rebecca Ugolick of the Howard Stallings Law Firm, and I represent the defendant appellant estate of Lewis Stocks. I'm going to try to keep this brief, but want to ask that any time left in my 5 minutes is reallocated to Wells Fargo and Mr. Benjamin for rebuttal. It is the estate's position to reiterate to the court here today that it is in alignment with Wells Fargo, as has been the case since the inception of the lawsuit at the trial court level. It is of the utmost importance to protect the financial interest and potential implications that could happen to the estate, but also it is very important for this court to consider and for me to advocate against this law created by our Court of Appeals that could have this devastating impact to property owners and the real estate industry in North Carolina as we know it. And as Mr. Benjamin said, in alignment with him and also with Ms. Stocks, 1-529 is the correct statute of limitations that applies to all claims for reformation for conveyances of real property or documents under seal. In fact, if the court accepts this position that is being advocated by all parties and continues to apply 1-529 to reformation claims, that will resolve the overarching problem here, because it'll ensure that all instruments receive the same protection from fraud or mistake and preserve the status quo that Mr. Benjamin pointed out has been the law of this state and the precedent set by this court for over a century. Back in 1906, in the cases that he mentioned with Peacock and Lee versus Rhodes, Maudlin, this court found that actions for reformation, that it is 3 years from the date of discovery of the fraud or mistake. Discovery of mistake or of fraud has to be the connector here. If this court does not allow for instruments of real property or instruments under seal to accrue from the date that mistake or fraud is discovered, then as Mr. Benjamin said, you will allow, the court will effectively allow people to be defrauded in year 11 and, year 12. And there's no reason to have reformation at all. And it is the estate's position that this court must impose a discovery component here as it relates to reformation and conveyances of real property, sealed documents. And, simply put, reformation exists from and stems from the principle of discovery. The concept of reformation would not exist if you found your mistake in a document conveying real property or a sealed document when it was drafted. And we ask that the court does impose that discovery component as it does, connect the overarching issue here. It is our position, though, that the Court of Appeals, frankly, just put a very serious long-term risk of substantial economic loss, disruption in the mortgage, lending, and real estate industries that necessitates the review and the correction of this court. The estate respectfully asks that this court prohibit the application of law created by the Court of Appeals that will devastate the rights of North Carolina property owners, increase transaction costs, heighten lending standards, less favorable lending terms. All of those will be passed on to the consumers of the state. Another devastating impact will be existing deeds and existing recorded and executed deeds of trust in this state will be impacted. With the lower court's decision, the majority single-handedly changed the enforcement of all existing loan and title documents in our state going back decades. So it is the estate's position that the majority opinion of the Court of Appeals must be reversed to correct any inequities in the application of this law. This is a law that prevents North Carolinians to have a chance to remedy a defect or fraud after year 10, and that just can't be the law in our state. The estate does respectfully ask that your honors reverse the Court of Appeals and reform the deed of trust. And I will go ahead and turn it back over to Mr. Benjamin if the court does not have any questions for the estate.
Thank you, counsel. I understand that's rebuttal time, so at this point, we'll hear from the appellee.
Thank you, Mr. Chief Justice, Associate Justices. May it please the court. My name is Kathleen O'Malley, and I represent defendant Tia Stocks. This case presents a unique procedural posture. As Mr. Benjamin mentioned, I think the parties are in agreement regarding the correct statute of limitations that should apply in this case. But that's not determinative of how this court should rule. Ms. Stocks is of the opinion that the Court of Appeals opinion reversing summary judgment should be affirmed, but on alternate grounds from those set forth in the majority opinion. Now, as I just stated, Ms. Stocks has argued consistently at the trial court, at the Court of Appeals, and before this court that the statute of limitations in section 152.9 is the correct statute of limitations to apply for an action for reformation based on fraud or mistake. There are a couple of cases cited by Mr. Benjamin, Levy, Rhodes, and Muse v. Hathaway, which I think address this, although they are distinguishable. In both cases, this court looked to whether the 3-year statute in 152.9 applied as opposed to another statute of limitations, and said where reformation is required, the statute in 152.9 has to control. And I think that in this case, or in any case for reformation, that establishes case law from this court that says 152.9 is the appropriate statute of limitations to apply in any case for reformation.
Ms. O'Malley, then do you agree with Mr. Benjamin that we ought to overrule Nation Star?
I do, Justice Ervin, I do. Now, as to if this court were to apply section 147.2, when it should be applied, this court does have cases which say without express statutory language, the cause of action accrues on the date of injury. Now, as Mr. Benjamin again noted, this court between briefing and oral argument decided Chisholm v. Campagna and said that a breach of contract, the cause of action for a breach of contract cannot accrue when the injured party has no reason to know or no way of knowing that the underlying breach has occurred. Now, I question whether that is the same, the notice required under that opinion is the same as the discovery language in 152.9. There is discovery language used in the opinion. However, Wells Fargo undoubtedly had reason to know of the mistake when they had, or a way of knowing of the mistake, when they had the documents in front of them in the file. However, I don't think this court ultimately has to decide that issue for two reasons. The first is that I don't think it's the correct statute of limitations to apply. The second is, as this court stated in Chisholm v. Campagna, whether or not a party should be on notice inquiry as to whether a breach occurred is a question of fact for the jury to be determined. And so the same evidence that supports submitting when reasonable or when discovery should have taken place in this case in the exercise of reasonable due diligence to satisfy section 152.9 supports submitting whether the party would have been on inquiry notice under 147.2, and that evidence should have been submitted to the jury to decide. Now,
so your colleagues on the with the opposing view indicate that the law can't be that a party should have been on notice at the moment that the mistake was done, because if that were true, then there wouldn't have been a mistake to begin with. So what evidence is there in this record, do you think, other than the initial error that caused the situation? What evidence is there that Wells Fargo knew or should have known?
Yes, Your Honor, and I'd like to answer your question and then elaborate on why the position of Wells Fargo and the estate is not quite correct on whether or not the time of execution can be the time when reasonable due diligence should have required a party to be aware of a mistake. The evidence in this case that was presented to the trial court shows that the circumstances of this closing were very unusual. What happened in this case was not that Ms. Stocks was called to the bank, sat at a table with someone from Wells Fargo, and executed the deed of trust. It was not that Wells Fargo communicated with her, sent documents in a secured portal, had her sign them, and they were submitted. What happened, and the evidence shows that Ms. Stocks was called by her father to his medical office and asked to sign a document for him to get a loan. This means that Wells Fargo took a form deed of trust, they handed it to a borrower who had an interest in getting it signed, and had that borrower have someone else sign it that Wells Fargo had not communicated with regarding the deed of trust. It was signed about a week after the note and then returned to Wells Fargo, at which point Wells Fargo did not review the document. It is Ms. Stocks' position that the fact that that unusual closing established that Wells Fargo should have exercised reasonable due diligence and reviewed the document. If they had done so, they would have discovered the mistake. And at the very least, the fact that yes,
is there any evidence that Wells Fargo knew the circumstances that you just described about your client going to Mr. Stocks, Dr. Stocks' office and signing it there?
No, Your Honor, there isn't. The evidence submitted is the testimony from Tia Stocks, but arguably that makes this even more unusual of a circumstance.
Well, I guess my question is, it seems to me that if you're saying there is an issue of fact with respect to the degree of Wells Fargo's notice, anything that would put them on notice that they needed to make further inquiry would have to be something that Wells Fargo knew, right?
Well, Your Honor, I think that the circumstances of the closing can be sufficient, particularly because Wells Fargo knew at that point that they had let the deed of trust out of their possession. They'd not given it to the person they were expecting to sign it or the person who did sign it. It was gone and executed a week after the note. And when it came back into their possession, they didn't review the document. I think that reasonable due diligence would have required at that point for Wells Fargo to review the document. And if they had done so, they would have discovered the mistake.
Is there any reason to believe from the facts that you've described that the contents of the document would have changed as a result of the unusual nature of the closing?
We don't know, Your Honor. I mean, if I'm understanding your question correctly, the contents could have been changed. They were not, but they could have been changed by any party who had the document out of the presence of Wells Fargo to get another person to sign it, someone who hadn't reviewed the document with Wells Fargo, hadn't communicated with Wells Fargo. And the possibility that they could have changed the document in and of itself is something that should have required Wells Fargo in the exercise of due diligence to review the document.
I mean, the mistake that Mr. Benjamin is seeking to have reformed, and I'm just using that word because that's his word, would have been in existence at the time that the document was generated by whoever prepared it and before this series of what you describe as unusual events. Is that right?
That's correct, Your Honor.
So why would help me understand why the series of events that you had described would have put Wells Fargo on notice that there was some defect in the manner that the document had been drafted originally?
Well, I don't think that that's quite the law, Your Honor. It's not that they need to be on notice of the defect, but what this court has said is that the injury stems from discovery by the aggrieved party or when the discovery should have been made in the exercise of reasonable due diligence. And I think that that's the question, is whether Wells Fargo exercised reasonable due diligence. And this court has said many times over that that's a question of fact for the jury. Specifically,
I'm sorry, go ahead.
I'm sorry, Your Honor. Specifically, this court said in Forbes v. Neal, a jury must decide when fraud should have been discovered, exercising reasonable due diligence, particularly when evidence is inconclusive or conflicting. In addition, the cases cited by Mr. Benjamin regarding when the mistake should have been discovered, generally speaking, confirm that it is a matter for the jury, not one to be decided on summary judgment. What they do say is that execution or registration by itself is not sufficient as a matter of law, in the context that for the purposes of summary judgment, the statute of limitations should not be held as a matter of law to bar an action when a party relies only on the fact that the document exists. But it does not foreclose the possibility that there are other facts and circumstances at the time of execution which should put a party on notice or should give the party the obligation in the exercise of due diligence, or where they should have, in the exercise of due diligence, discovered the mistake. The Court of Appeals looked at this in Wells Fargo v. Coleman, and similarly, the defendants alleged that at the time of execution, Wells Fargo should have discovered the mistake. And it was a mistaken property description in a deed of trust. And they said Wells Fargo should have double-checked the property description against the appraisal and the tax ID. And the Court of Appeals said, that is a matter for the jury to determine. We cannot determine on summary judgment whether that evidence supports the statute of limitations. Those facts need to be submitted to the jury.
Did your client act in any way inconsistent with as if she had actually signed the note?
She was never a borrower on the note.
No,
She
no. Did she act? In other words, did she make payments based on the payment schedule in the note for a significant period of time?
She did, Your Honor, and she doesn't deny that. She has contended that she told her father that she would pay for as long as she could. And she submitted paperwork to Wells Fargo for the payment to be electronically debited. It was actually from a trust account for her daughter. And she did make payments as long as she could. Yes, she was paying the mortgage payments on the schedule while she was living in the house, but she never signed the note. She was never a borrower.
So based on her behavior in terms of making the payments for a significant period of time, there was nothing that would have put the lender on notice that she would be contesting the validity of the note.
But Your Honor, she's not contesting the validity of the note. The validity of the note is a different question, and that goes to the standing of the estate, which is another argument we've made.
Yeah, well, let me put it another way, that she would be contesting the transaction as it relates to the deed of trust.
No, Your Honor, but she had no basis to contest it until it came to Wells Fargo trying to foreclose. And this goes to the intent of the parties, which again is another issue which the case law from this court has said is a matter of fact to go to the jury. And that relates intricately with the strength of the evidence. Wells Fargo's evidence must be clear, strong, and convincing under the case law from this court. This court said that in MP Hubbard and Co. v. Horn. And also said in that same case that the strength is an issue from the jury. And in Archer v. Cole, this court made clear that if there's not a meeting of the minds, there is no instrument to reform. And that's where we run into the issue. She did not know that she and Wells Fargo disagreed as to what this instrument was meant to embody until Wells Fargo went to foreclose. What Ms. Stocks has said, and the evidence that she has submitted, is that says that she intended to be a surety. She did not intend for Wells Fargo to be able to foreclose on her home as a primary recourse for a default on the note. They should have had to go after the estate first. And whether Wells Fargo contends that it was a mutual mistake that the deed was not, or the deed of trust was not executed in a way that allows them to foreclose on the property as primary recourse. Now, the fact that she's offered direct testimony regarding her intent, that alone is evidence which would send this to the jury. She did make admissions, and she did in her interrogatories state that she intended for the property to be collateral for the loan, but no interrogatories or admissions ever asked her whether this second deed of trust or her understanding of the first deed of trust was that it would be foreclosed on by Wells Fargo if there was any default in the loan as a primary source of recovery. And she has testified, again, direct testimony regarding her intent, that her understanding and her intent was that her property would serve as recovery if Wells Fargo could not collect from her father.
Let me ask you for some clarity about a couple things. It's my understanding that you are contending that there are issues of fact that need to be resolved, and the case needs to be remanded to the trial court for that purpose.
That's correct.
Can you specify what those issues of fact are that you think the trial court needs to resolve here?
Yes, Your Honor, there are three. This court's case law establishes that, one, the mutual intent of the parties is an issue of fact to be determined by the jury. Two, the strength of the evidence, whether it is clear, strong, and convincing, is an issue of fact to be determined by the jury. And when the discovery of the mistake in the exercise of reasonable due diligence is an issue of fact to be determined by the jury. Now, I will candidly say there are a couple of Court of Appeals cases which have determined the strength of the evidence on summary judgment. There are no cases from this court that have. The only case from this court where the court made the determination as to the strength of the evidence is Heiss Mill, and it was a bench trial. Now, in the Court of Appeals.
So is it your position that the determination of whether, when you say strength of the evidence, you mean whether the evidence was clear, convincing, that sort of thing, that's an issue of fact and not an issue of law for the trial court?
That's right, Your Honor. Whether the evidence is clear, strong, and convincing. This court said that again in MP Hubbard and Company v. Horn. It said it in Archer v. McClure. And in the cases where the Court of Appeals made the determination in Metropolitan Property and Casualty Insurance in Company v. Dillard and in Nation Star, there was no indication that there was conflicting or inconclusive evidence presented. I think that's the only possible case in which a court could make the determination itself where there was only evidence presented by one side or there was agreeing evidence presented by the two sides. And again, Ms. Stocks made admissions regarding her intent to have the property collateralize the loan, but she qualified those admissions. If you look at the admissions, they all say, admitted, I intended to act as a surety. And so those qualified admissions show that her intent was not for Wells Fargo to be able to foreclose on this loan as primary recourse. And that's where we also run into the lack of a mutual mistake, or at least a factual issue about whether there was a mutual mistake, which needs to go to the jury. Because for a mutual mistake, both of the parties need to have the same misconception, the same mistake in the document. And that's not what happened here. Wells Fargo wants language to be included in the deed of trust. Incidentally, if both of them are listed as borrower, that's still just an incorrect reflection of the facts. But Wells Fargo wants language to be included, which allows Wells Fargo to foreclose on the deed of trust as a primary recourse for default on the loan. Ms. Stocks has testified that was not her intent in signing the document. Her intent was for Wells Fargo to have to collect from the estate, and if they couldn't collect, and from her father, to be clear, he had not passed away at the time, collect from her father, and if her father could not pay, to then be able to collect against the property. I think that allowing Wells Fargo's affidavit, Wells Fargo's evidence in this case regarding the mutual intent of the parties is the documents themselves and an affidavit from a Wells Fargo employee who reviewed the documents who never spoke to Ms. Stocks. And so Wells Fargo's evidence of Ms. Stocks' intent comes directly from the existence of the document itself, the loan documents that she signed. To determine on summary judgment that that can overcome Ms. Stocks' direct testimony regarding her own intent, really overlooks the factual issue and overlooks the ability of a party to raise the issue of intent sufficient to get to a jury. A party should be able to testify as to their own intent. Really, that's the only evidence of intent, or the most direct evidence of intent a court can receive. And so to overlook that on summary judgment really overlooks the purpose of summary judgment and not having issues of material fact.
Can I ask you a question to make sure I understand what you're saying, what you're contending about the facts? So in terms of Ms. Stocks' intent at the time these documents were signed, you're saying it was different. It wasn't merely a refinance. It was a different type of transaction than the one she originally that originally happened back in 2002?
No, Your Honor, I'm not saying that, because there's actually no evidence regarding her intent as to the original transaction in terms of whether she thought that deed of trust also would provide only secondary recourse for Wells Fargo. None of the interrogatories or admissions asked her what her intent was in terms of when Wells Fargo could collect against her property. It was a refinance of the property. What she has testified to as well is that she had no idea it was a refinance. At the time that it was done, she didn't know her father was taking out the loan. She did admit that it refinanced the original loan. She said she found out later that he used the money to pay off the loan.
Is it her contention that she didn't understand that a refinancing involved placement of one obligation with another?
There really is nothing, whether she did or not, I'm not sure that that affects her her intent in signing the document. Again, there's no evidence that her intent in signing the original deed of trust was to have Wells Fargo be able to foreclose against her property as a primary source of recovery on the note.
Is there anything about the documents associated with the original transaction that would have rendered that transaction any different than the normal transaction that you get yourself into when a house is purchased, other than the fact that we had the money coming from one source and somebody else living in the house?
No, Your Honor. She received the house, she signed the deed of trust, but she was not the borrower on the loan. So, I mean, it was unusual in that respect, in that she was not the one who signed the loan document, the note itself. She was not the borrower on the loan. She did not receive the money. But no, there wasn't anything that is in the record that shows that that was unusual, other than that particular oddity.
Okay, thank you.
How do you reconcile your position with this 115 years of precedent that the other side continues to emphasize?
Well, Your Honor, I think that Mr. Benjamin has pointed to the 115 years of precedent as this court applying the 3-year statute of limitations in 152.9. Is that what you're referring to, Your Honor?
Well, yes, and the fact that you continue to talk about the aspects of this particular fact pattern that's presented in this case, and that there should be a genuine issue as to material fact as to when the discovery should have been made, understanding that the Chief Justice has also brought to our collective attention that if the 3 years would run from the date of the mistake, then the mistake would not have been made, presumably, at the time, if that's the time of discovery. But you're saying that that should be a question for a jury. How does all that reconcile in light of the 115 years of precedent concerning how reformation should be considered?
Right. Well, Your Honor, what the 115 years of precedent says is that when the mistake should have been discovered in the exercise of due diligence is a matter for the jury. Now, Wells Fargo has a quote in its brief from Pelletier v. Interstate Cooperage regarding the fact that notice existent in a deed is not sufficient as a matter of law. But again, facts and circumstances at the time of execution can require someone to discover the mistake in the exercise of due diligence. And the full quote, the quote is incomplete in Wells Fargo's brief, and the full quote actually says, it ends with, in the absence of actual knowledge or negligent inattention, the question as to the date when the action accrued is usually one for the jury under all the facts and attendant circumstances. So really the question is not just, did registration itself put Wells Fargo in a position where it should have exercised reasonable due diligence and discovered the mistake? It is, did the facts and circumstances of this execution, of this closing, put Wells Fargo in that position? And that's a question for the jury to determine. Ms. Dox's position is not simply that because the face of the document showed a mistake or because it was recorded, that's what Wells Fargo, we should have triggered Wells Fargo's accrual of a cause of action.
So just to make sure that I understand your argument, Ms. O'Malley, you're saying that the fact that the documents were executed by your client under a set of circumstances such that she was called to Dr. Stokes' office, told what you have recounted, and signed it in Dr. Stokes' office rather than in the context of a more traditional closing, that fact should have caused Wells Fargo to make inquiry into the manner in which the documents were drafted?
Yes, Your Honor, because it means that Wells Fargo, it means that they should have reviewed the document. Because,
okay, all right, I'm just trying to make sure I understand if I got your argument correct, you think?
Yes, and not that they should have looked at the way it was drafted so much as they should have reviewed it when it was returned to them. whether it was
But the review that they should have conducted would have included the manner in which the document was drafted.
Yes, Your Honor, it would have, yes. And the last thing I want to address briefly is Ms. Stocks' argument that Wells Fargo shouldn't be entitled to relief in this court. Wells Fargo should be stopped from receiving relief in this court because they are the party that argued for the application of 147.2 in the Court of Appeals. Wells Fargo has tried to disavow this opinion. Wells Fargo has tried to say that they raised the issue of 152.9 at the Court of Appeals. They in fact did not. Their brief said specifically that the applicable statute of limitations was 147.2. The Court of Appeals in its opinion said that Wells Fargo expressly argued, and that was their language, expressly argued that the application of 147.2 was the correct statute of limitations. And when Wells Fargo only cited 152.9 once in its brief, and that was to point out that Ms. Stocks had pointed out that both parties argued for 152.9 in the trial court. Now, the cases from this court, there are cases from this court that say you cannot switch your position. I cited two, Rand G. Villette and Cannon v. Assad, specifically with regards to legal positions that say a party cannot switch their position between courts to their own benefit. Now, generally, those have been applied between the trial court and the appellate court, but there is no reason why that should be any less valid between levels of the appellate court. We are here today because Wells Fargo argued for the application of Section 147.2 to its claim and then was unhappy with how that was applied because there was no language in the statute that allowed for delay of the accrual of the cause of action. This is akin to what happened with the party in Rand v. Gillette, where the defendant argued that there were liens that were invalid liens that were valid because he wanted to prevent a judgment creditor from collecting. So he argued that there was a valid deed of trust on his property. And the court said, okay, you're right, it's valid. They can then come and collect against you. And the lender came then to foreclose who held those valid deed of trust. And the party came back and said, nope, sorry, I disagree. They are not valid liens of trust. And this court said he induced the court to adjudge the instruments as valid. And if this were erroneous, he has no one to blame but himself. And this is a similar position here. It's true that there was a prior Court of Appeals opinion, but there's no reason that all of the precedents cited by Wells Fargo to this court couldn't have also been cited to the Court of Appeals to show that there was binding precedent from this court and from prior Court of Appeals opinions, which showed that 147.2 was not the applicable statute of limitations. It's notable that Wells Fargo has not made this argument in a previous case in Wells Fargo v. Coleman for the application of the 10-year statute of limitations. It simply was not addressed by the Court of Appeals because they raised it for the first time at the Court of Appeals. And so Wells Fargo has been looking for this 10-year statute of limitations to apply, but then was unhappy with the position when it was applied and seeks to disavow the argument before this court. This court should not allow that kind of disingenuity in their argument. And so because of the genuine issues of material fact, we believe that despite the fact that the correct statute of limitations to apply should be Section 152.9, the Court of Appeals opinion reversing summary judgment should be affirmed, but on alternate grounds. Thank you, Your Honors.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. I only have 2 minutes. I'll stand on our briefs on the issue of that you raised at the Court of Appeals. They already made the Court of Appeals, but on the statute of limitations argument, this court has held in Pemby versus Cape Fear, the Supreme Court in 1985 case, that a statute of limitations is an issue of law when the facts are not in conflict. In Teal versus Kerr, the Supreme Court found the same thing. The majority below in Stocks said the trial court may have been correct in rejecting the Stocks argument because the evidence does not suggest the existence of facts or circumstances that if pursued would lead to the discovery of facts constituting the mistake. In the argument itself, down in the record, which is the part that where we talk about the irony of her position that she just stated, This was the extent of their argument on page 23. They talk about statute of limitations. I think that the statute of limitation runs once it should have been discovered. Now think about this. When should it have been discovered? The bank drafted the note. The bank drafted the deed of trust. When should they have discovered that something was wrong with those two? They should have discovered it that day. If the argument is 12 years later, they can say, ooh, we made a mistake. And that was a mutual mistake. Finally, on page 420 to 421 of the record, we asked for the full factual basis of her defense to reformation. She did not even state the statute of limitations anywhere in there. She admitted throughout her reformation, I've got 20 seconds left, throughout her her admissions and in her interrogatory 26 of page 417 of the record, there's no way I could know the intent of my father, but my intent was to pledge my house as collateral on my father's loan. And we cited the cases that allowed this court to grant summary judgment as a matter of law. Under Rule 56, you didn't present any evidence to contradict those 2 points. You can't make it up now. Thank you, Your Honor.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court. All right. Thank you, counsel.